Hi everybody, welcome to Law Hero, and I'm going to film this video about insolvency. Insolvency for corporates. You can also be insolvent as a person as well. But this is a very, very big topic in the FE1 company law, especially given the fact that our examiner, Dr. Tom Courtney, is an insolvency practitioner himself. When we think of insolvency, we normally think of liquidation, be it members or creditors, voluntary or involuntary liquidation. We also think of receivership and examinership, but I want to go a step back from all of that and look at the steps that lead up to actually being insolvent. There are two different tests to determine whether a company is insolvent, and I'm just going to get my trustee Companies Act. So actually the first test comes under section 570 of the Act. It says circumstances in which a company is deemed to be unable to pay its debts. So there it is. It's on page 510, and this is a measure of whether the company is able to meet its debts as they fall due. So if they get in a bill, whether they can pay it or not, and if their creditor finds that they're not paying, they're entitled to send this 21-day demand letter, and if it hasn't been paid, then they are insolvent. Insolvent simply is you can't pay your debts as they fall due. And the sum has to be over 10,000 euros, by the way, under A Part 1. You'll see all that in the Act. Another way to figure out if a company is insolvent is to check its balance sheet. And balance sheet is normally a statement of assets and liabilities. It's a good way of figuring out whether the liabilities of the company are greater than the assets. And if the cash flow test fails, as in if you're unable to pay your debts as they fall due, then you go to the balance sheet, and if things are okay there, the directors actually have a defense if they've been accused of fraudulent or reckless trading, because they can say, well, on the face of it, it looks like our assets are greater than our liabilities. It looks like we are solvent on our balance sheet. We weren't really looking at how our working capital was servicing our debts, and therefore we have a defense. We didn't know that the company was insolvent, because directors have a duty to their creditors and not their shareholders. When a company becomes insolvent, which we've just learned the meaning of it, and I am appointed as the liquidator or the receiver, I will look at the contracts which are outstanding, and I will check if there's an ROTC clause. And because I'm trying to get the most value for the company, I will argue that that clause is not properly incorporated into the contract, or because it's not registerable as a security, that it is invalid. That's why it's very important that if you're a solicitor acting for the vendor or the supplier of goods and services, that you ensure that the ROTC clause is properly drafted, that you know the law around it, which you're learning for the FE1. That it's valid. So this will depend on the type of clause you use. There are a few, and we'll go through them in a minute, and also the facts of the case, as in what type of goods or services are at issue. The two most common ROTC clauses are as follows. A simple retention of title clause means that title of the goods does not pass to the buyer until those goods, so those particular goods, have been paid in full. So this is transaction based. It depends on those goods. The opposite is the all sums due clause, and that means title does not pass until all sums owed by you to me have been paid. So it's not transaction based, it's debt based. There's also the proceeds of sale clause, which is not so common in the FE1, but it basically means, and you'll see this normally in lending transactions. If you sell the goods that I give you, I'm entitled to the proceeds of those. And then there's a lot of case law around that. The Scottish Timber case, or Scottish Timber Products case, where the goods have been incorporated so as to lose their identity, the ROTC will not be effective. And I think this is what people call the mishmash of products. Like, for example, if your timber becomes chairs, it's very hard, and like as in you've mixed it with nails and other things, it's very, very hard to identify the original product that the ROTC attaches to, so it loses its validity. In Peachdart, it said where the goods cannot be extracted or removed from the end product, the ROTC will not be effective. That's the same principle. In Hendy Lennox, it said where the goods are readily identifiable and removable, the ROTC is effective. So it depends on the circumstances of the case and of the goods and what has happened to them kind of post being delivered. Okay. So now we have the scenario that the company has gone insolvent and we have a liquidator in place. First of all, if you're a creditor, you have to tell the liquidator that you are owed money, and so that's very important. You need to prove your debt, and the onus is on you, that it's a bona fide debt. So this is under 619 and 620 of the Act. So when it comes to priority of payouts in insolvency, I'm going to read out the following for you. So obviously debt gets paid first, all types of debt, before any equity is looked after. So that's why shareholders are at the very, very bottom. But when it comes to debt, there is a hierarchy of priority when it comes to creditors. So first of all, the examiner is paid if there's an examiner. Then the fixed charge holders, so that would normally be like the banks. And then the expenses of the examiner comes third, and that's under section 529. Then fourthly is the cost of the winding up. Fifth are the fees of the liquidator. Sixth are super preferential debts, so this is like PRSI, revenue, income tax stuff. I don't know a lot about that. Then the second preferential debts are like rates, commercial rates, taxes and salaries of employees. Then you have your floating charges, and this is why being ranked as a floating charge, it's not great. And then you have your unsecured debts, and they're pari passu, which means they're at the same level as against each other. And then you have your deferred debts. That's the very, very last, and they also rank pari passu. Pari passu is under section 618 of the Act, and it just basically means that all debts rank equally, and where assets are insufficient to meet them, they are abate in equal proportions. There are some exceptions, but just take it for the FE1 that unsecured debts and deferred debts are paid pari passu. Okay, the next thing I'm going to touch on is directors' exposure when a company is found to be insolvent. The first one, as I already mentioned, is reckless trading. Oh no, reckless trading, and that comes under 610. A director will be deemed to have traded recklessly if she, having regard to the skills and experience of expected of a person in her position, knew or ought to have known that her actions of the company or those of the company would cause loss to the creditors, or she was part to contracting a debt by the company and did not honestly believe on reasonable grounds that the company would be able to pay the debt as it fell due, as well as other debts. A good case around reckless trading is Heffernon Kearns, and the reason that's a good case is because they had actually gone and noted in the minutes the state of financial affairs of the company, and on that basis the directors would have been readily informed as to that the company would not be able to survive and meet its debts. For a director to be guilty, the director must know there is an obvious and serious risk of loss and damage to others, and they must ignore this risk. And so the next second one is fraudulent trading, and that comes under section 722. There's also a failure to keep books and records, that's under section 282. For these you may get criminal liability under section 286, and also you may be declared personally liable also under section 286. You may also be restricted as a director under section 819, and under restriction the yardstick of dishonest or lack of responsibility comes under La Moselle criteria, which was approved in Resquash, Ireland. They'll look at the extent to which the director has complied with the Act, the extent to which the conduct could be regarded as incompetent as to amount to irresponsibility, the extent the director's responsibility for the insolvency itself, the extent the director's responsibility for the net deficiency in the assets disclosed at the date of wind-up, the extent to which his conduct of the affairs of the company displayed a lack of commercial probity or want of proper standard. If all comes to all, you could be disqualified under section 842. Also bear in mind there's fraudulent preference under section 604, and this has to do with any payment made by a company which at the time of making it, the company was unable to pay its debts as they fall due, so the company was insolvent. So if a payment was made within 6 months, or if it's a connected person under section 220, 2 years before the commencement of the wind-up, it will be deemed. I'm not going to go through liquidation, receivership and examinership because they are looked after very, very well in my ebook. But I will note one thing, which is the impact of a liquidator on directors. So the liquidator becomes the executive officer of the company in liquidation, and he acts on behalf of the company. So you'll see, like, if it's KPMG, you'll see Kieran Wallace, KPMG on behalf of X Limited. He will do all the acting on behalf of the company. He has the power and authority, and directors lose their authority. They have to cooperate with him. He has to compile a report, a 681 report it's called, 681 report, and his findings may mean that the directors become restricted, and based on his report there's various actions which can be taken against the directors. Yeah, that was just like a whistle-stop tour using the Act around insolvency law in Ireland. It's just a little recap for all of you before the FE1. As I said last year, and as I predicted last year, examinership was a hot topic. You need to know insolvency very, very well. Please don't avoid it. You know, a lot of people love the incorporation stuff, but that's pretty basic. You need to know how a company dies as well, and also remember who your audience is. I mean, this is a person who does it a lot. So yeah, if you have any questions as well, please get on to me at info@lawhero.eu or on Instagram. And yeah, best of luck in your FE1 company law. If you need extra notes, please go to my website. I have other videos as well around company law. Yeah, again, thank you for watching, and please subscribe.